which proposes a fourfold test to determine arbitrability. As per the judgment, an issue is not arbitrable if it relates to the actions in rem that do not pertain to the subordinate rights in personam that arise from the rights in rem, affects third-party rights, have erga women's effect, require centralized adjudication, and mutual adjudication would not be appropriate, relates to inalienable sovereign and public interest functions of the state, is expressly or by necessary implication non-arbitrable under specific statute. Generally, the fact that the subject matter of the dispute relates to telecom will not affect its arbitrability. In few types of telecom disputes, however, arbitrability can come into play due to state control of telecommunications networks and policy consideration at stake, leading the national authorities to reserve particular matters for decision by the tribunals. Therefore, the arbitration is barred in respect of matters which are within the exclusive jurisdiction of TDSAT under the provisions of Troy Act 1997. I am referring to a judgment of the Kerala High Court on this aspect, A. Salim versus Assistant Satellite Communication Limited, 2022. The question on arbitrability of a dispute was raised in Viom Network Limited versus S. Airtel Private Limited, wherein the Delhi High Court held that the dispute between the telecom licensee and the infrastructure providers must go to TDSAT and not to be decided by the arbitral tribunal. This decision stems from the interpretation of the provisions of 2(1)(e) and J, which provide for the definitions of the licensee, service provider, respectively. Prima facie, it appears that TDSAT has broad exclusive powers to adjudicate certain types of disputes, including those arising between private parties, where arbitration cannot be resorted to. This hampers the spirit of party autonomy, which is integral to arbitration. With some exceptions, Indian courts and TDSAT itself have generally found telecom disputes to be non-arbitrable on the basis that establishment of special tribunals overrides the more general Arbitration Act. I read this judgment also. This therefore raises the questions on the arbitrability of telecom disputes in the light of the exclusive jurisdiction of several matters with TDSAT and consequently the diminishing rule of arbitration in this area. According to the is a section of Section 7B of the Indian Telegraph Act which provides for statutory arbitration. Under Section 7B, any dispute concerning a telegraph line, appliance or apparatus between the telegraph authority and the person for whose benefit the line, appliance or apparatus is or has been provided has to be determined by arbitration. Such dispute has to be referred to an arbitrator appointed by the central government, either especially for the determination of that dispute or generally for the determination of the disputes under the section. A recent judgment of the Supreme Court in Vodafone Idea Cellular Limited versus Ajay Kumar Agarwal discusses the ouster of jurisdiction under Section 7B of the Telegraph Act. In this case, the maintainability of the complaint filed before the District Consumer Redressal Forum came up before the court in the light of Section 7B of the Telegraph Act. That Section 7B housed the jurisdiction of the Consumer Forum. The court held the existence of an arbitral remedy under Section 7B will not house the jurisdiction of the Consumer Forum and that it is open to a consumer to opt for the remedy of arbitration, though there is no compulsion in law to do so. Therefore, it was open to a consumer to seek recourse to the remedies which are provided under the Consumer Protection Act 1986, now replaced by Act of 2019. The mediation bill is being discussed at length in different fora, and it is very likely that the mediation would become an act. It can thus be seen that the business community at large is interested in the alternative dispute resolutions. The telecom disputes should also be referred to arbitration by following party autonomy with necessary caution. It is not that every dispute is arbitrable. The fine distinction has to come by way of judicial pronouncements, and TDSAT would consider the proposition in appropriate cases and the march of law. Having said this, it is necessarily to be remembered that considering the progress that the tribunal has made and the number of cases that they have disposed of, if that is more viable, in my respectful submission, TDSAT should continue, because ultimately, if ultimate idea is that justice should be delivered speedily, whether it is by arbitration, mediation, or through proper adjudication by a tribunal. Thank you so much. Jai Hind, Vande Mataram.
Thank you so much, sir. We are honored to have you with us today. Our next guest, I'd like to introduce Shri P. Wilson, Senior Advocate and Honorable Member of Parliament. Senior Advocate Shri P. Wilson has served the legal fraternity as well as the country in his role as a Rajya Sabha member, member of Committee of Personal Public Grievances, Law and Justice member, Committee of Privileges member, Consultative Committee of Defence. He is also a coordinator for Niti Karangal, a pro bono program conceived by him and is conducted in coordination with the Tamil Nadu Advocates Forum to help the poor litigants to effectively defend their cases before various courts. He has participated in debates with regard to bills and motions brought forward and has also had an active role in the special mention 0-hour questions, including debate on Arms Amendment Bill 2019, Surrogacy Regulation Bill 2019, to name a few, and indeed they are a reflection of his wisdom and intellect. Sir, I would like to welcome you to please grace us with your presence.
Honorable Justice M.M. Sundaresh, Judge Supreme Court of India, Honorable Justice T. Raja, Acting Chief Justice, Madras High Court, Honorable Justice Anita Sumant, Honorable Justice Saravanan, Honorable Justice Abdul Qudus, Honorable Justice Dhirubhai Narayanbhai Patel, D.N. Patel, affectionately called D.N. Patel, Chairperson of TDSAT, Honorable TDSAT members, Justice Ram Krishna Gautam, Mr. Subodh Kumar Gupta, through S. Sankaranarayanan, Additional Solicitor General of India, through A.R.L. Sundaresan, Additional Solicitor General of India, through S. Prabhakaran, Vice Chairman, All India Bar Council, through S. Muthukumar, State Government Paid at Madras High Court, the officials from ELCOT, Secretary Information Technology, senior advocates, other dignitaries who have come to attend this seminar, ladies and gentlemen, press and media, vanakkam to you all. This day is the happiest day, and I am privileged to be present here as a special guest at a seminar hosted by the Telecom Disputes Settlement and Appellate Tribunal in Chennai. Information technology is now the backbone of our society. We are truly in a digital age where we use information technology for every facet of our lives. During the pandemic, we saw that even weddings happening over Zoom. It is of particular importance to economic growth. Of course, we also witness the drastic shift to virtual courts. Earlier, we thought rendering justice is within the four walls. This corona has taught us many things. Now we can understand that justice need not be delivered within the four walls. It can be delivered beyond that. The judges sat at the residence, lawyers sat at the residence, and the cases were argued through virtual courts. That's the shift we saw during this pandemic period. In any sector, economic growth brings commercial litigation. Commercial litigation is an unavoidable consequence of economic development. It is essential for the government to provide an efficient platform for the speedy and effective resolution of commercial disputes to aid economic growth and investment in the sector. If there is no effective resolution of commercial disputes, the sector will stagnate. It is important for us to remember that the concept of access to justice has been etched in our Constitution. Considering the fact that TDSAT is located at New Delhi, which is not equidistant to all parts of the country and is far away from many states, particularly the southern, western and eastern states, the citizen located in these states were being deprived to approach the tribunal not only due to the distance but also due to the cost factor. From the point of view of lawyers in Delhi alone had access to TDSAT. As broadcasting, there was an undeniable need for a regional benches of TDSAT. As broadcasting petition and appeals, cyber appeals, ARA petitions and appeals and telecom petitions and appeals are being dealt by TDSAT, thereby requiring a regional bench in an IT hub like Chennai to help administer effective and speedy justice without overburdening the judicial avenues present. Therefore, under the guidance of the Honorable Chief Minister of Tamil Nadu, Mr. M.K. Stalin Avargal, I met the Honorable Union Minister of Communications, Electronics and Information Technology through Ashwini Vaishnav and gave him a representation for establishment of regional benches of TDSAT in Chennai, Mumbai and Kolkata. I am grateful that he immediately accepted my request, and that resulted the circuit benches being formed and notified, and that is how the circuit bench for the first time sat in Chennai yesterday in this premises and heard matters. I thank the Honorable Union Minister through Ashwini Vaishnav and Honorable Chief Minister through M.K. Stalin, and also the Honorable Chairperson for making possible this historic sitting of the TDSAT at Chennai. Circuit benches makes justice accessible to all and at an affordable cost. No litigant should be disadvantaged either by locational or economic handicaps or otherwise. Justice delivery system should be taken closer to the stakeholders and litigants and to the common man, and opening of a circuit benches in Chennai is beginning of distributive justice in southern India. Let's hope that the circuit bench transforms into a permanent bench and the union government takes steps to amend the TRI Act accordingly and establish regular benches in near future. That would be our request also. This will also help to ease the burden on the TDSAT as it looks into the various matters and disputes arising under the Information Technology Act 2000, Airports Economic Regulatory Authority of India Act 2008, and now I heard even the Aadhaar. I think the many more works may be given to this tribunal. Now all the tribunals are brought under the Tribunals Reforms Act, and the tribunals have been drastically reduced. Now today, if you see, there are hardly 17 tribunals, if I am not wrong, located throughout India. With the commencement of the circuit bench, the litigation cost for the subscribers, consumers, multi-system operators, DPOs, broadcasters, cable TV operators, telecom companies, and consumers who wish to approach the tribunal would reduce. Further, the members of the southern states, bar from Kerala, Karnataka, Telangana, Andhra Pradesh, Tamil Nadu, would have the opportunity to appear before the tribunal without going to Delhi. I think my friends from Delhi should not mistake us. We have a great pleasure to see you all here, coming us and effectively participating. So, these southern state, the bar from the southern state would be enriched. This is a new avenue. In fact, the learned Additional Solicitor General said about the mediation bill. That is another avenue. Please wait. The ensuing parliament session, after our standing committee's report, the government is going to introduce again before the parliament. I don't know whether our suggestions or amendments are taken care or not, but we went throughout India, we went to the High Court, This is the first time the Parliamentary Standing Committee visiting to the High Court, hearing the views of the Chief Justice, judges, the stakeholders, namely the lawyers association, and taking all their views into our report. And we have submitted this report before the Parliament and hope it would fructify as a very good bill, and let's wait for that. The Tamil Nadu government, under the leadership of Honorable Chief Minister Mr. M.K. Stalin, has always strived to provide the requisite infrastructure to judiciary. I would say with pride that our Chief Minister has recently allocated about 4.7 acres of land in the heart of city worth several hundred crores to the judiciary for constructing a multi-storied combined court building to accommodate sessions courts, civil courts and small causes courts and family courts, which are now functioning inside the Madras High Court campus. Please visit our Madras High Court campus. It is about 33 acres, one of the oldest building with large court halls. So they wanted to have the entire premises for the Madras High Court, and that's how they wanted to shift to the nearby place, and that's how the government has given 4.7 acres of land along with another 3 acres. So totally 7.7 acres of land in the heart of city now is going to be developed for the court buildings. The building would accommodate about 160 court halls, I am told, which would earlier operating inside the Madras High Court campus and outside the Madras High Court campus. I take this opportunity to request our beloved Honorable Acting Chief Justice to kindly consider setting apart few court halls in the combined court complex for the circuit benches and regional benches of tribunals like TDSAT, NCLAT and other tribunals, so that some court halls can be specifically given to circuit benches or the permanent benches. The circuit benches like TDSAT, they can come and use the court halls. They can have a separate record room in that premises, and this will help the lawyers. They need not go here and there. The NCLAT is functioning elsewhere, so all the tribunals, the NGT is functioning elsewhere, so all the tribunals can be brought in that complex, because large extent of land is given by the government to the judiciary. So I appeal to the Honorable Acting Chief Justice, and our beloved Honorable Justice M.M. Sudaresh is also there. I hope they would consider my request. It is imperative for the proper functioning of a tribunal that we make available suitable infrastructure and sufficient staff. I have already written a representation on 11/10/2022 to the Honorable Union Minister in this regard, and I am happy to announce that in his reply he has stated that a comprehensive proposal for amending TRA Act is under consideration, which also consists the proposal to increase the number of members of TDSAT, and furthermore the proposal for additional office space is also under consideration. I appeared before the Honorable Chairman in certain cases in Delhi. I am sorry to say that the TDSAT is functioning in a Hotel Samrat, and we have court hall, and inside the court hall there is a toilet. I was really surprised to see such sad state of affairs, and therefore I had taken up this matter also to the Honorable Union Minister, and hope they will get a very good building in near future. I hope the Union government equips this tribunal well, so that such a powerful and potential industry only grows and pending cases are disposed of as swiftly as possible, thereby removing any hindrance to the growth of this industry. I must register my appreciation of the Honorable Chairperson, Honorable Members and other officers of TDSAT for efficiently discharging the functions of the tribunal despite having inadequate staffs and infrastructure. I could see the records kept on the floors. There is no record room at all, and voluminous records are there. The cases they are fighting is of high volume. You would have seen the claim would be running to several hundred crores, but there is no record room. That is the saddest state in which the TDSAT is functioning now. I hope this seminar spreads awareness regarding the hard work and efforts of the TDSAT and the telecommunication industry, and that the new regional circuit benches help ease the burden of the pending disputes at the tribunal, thereby allowing for expansion and improvement of the sector, and help the member of the Tamil Nadu bar and the southern bar, these people from Andhra Pradesh, Kerala, Telangana, be benefited and to create a niche practice. There are more than 70 tribunals functioning across the country. However, the appellate tribunal constituted under the Smugglers and Foreign Exchange Manipulators Forfeiture of Property Act 1976 and the appellate tribunal for electricity do not have a regional benches or circuit benches. Moreover, the circuit benches, appellate tribunal for electricity were notified. However, they are not functioning at all. We will bring APTEL to Chennai as well. This is another work which we are going to undertake. APTEL, they originally had this circuit benches. There was no reason why they stopped the circuit benches. So we assure that we will bring this APTEL to Chennai. Lastly, since Honorable Justice M.M. Sundaresh is here, I want to say this also. Our dream is to bring the regional benches of the Honorable Supreme Court to Chennai as well. And we hope that dream becomes a reality within this tenure on the bench of the Apex Court. Mr. Prabhakaran is also there. I don't think so All India Bar Council would oppose this. I thank Honorable Chairman, members of TDSAT for giving me this opportunity. I also thank, in fact, Mr. Mano Tangaraj, who was about to attend. He couldn't come because of his sudden work in Erode. And we thank the IT department, Government of Tamil Nadu, and the LCOT for giving support for organizing this seminar today. Thank you very much.
Sir, thank you so much with your kind permission. Honorable Mr. Justice D.N. Patel, sir, with your kind permission, I would like to say that we have the honor of having with us today Justice Abdul Qudus, Justice Sarvanan, and Justice Anita Suman. Can I please request you that give us an opportunity to grace you? Shri S.K. Bhattaji, please felicitate. Thank you so much, sir and ma'am. We are honored with your presence. The next speaker, I would like to introduce Honorable Mr. Justice T. Raja, Acting Chief Justice, Madras High Court, who has had quite a journey from commencing from Madras High Court and shifting his practice to Honorable Supreme Court at New Delhi. In New Delhi, he's practiced in Civil Criminal Constitution Service laws before the Honorable High Court of Delhi, Central Administrative Tribunal, and Supreme Court. He's also served as a standing counsel for Dr. MGR Medical University for about 10 years in the Honorable Supreme Court. He's also served as a standing counsel for ESI before the Principal Bench, Central Administrative Tribunal, New Delhi, as well as in Delhi High Court and Honorable Supreme Court. He has served as a standing counsel for Honorable Supreme Court Legal Services Society for all civil and criminal matters for about 6 years. He was appointed as an Additional Advocate General at Madrai Bench of the Madras High Court in February 2008 and has appeared in several important cases. He was appointed as Additional Judge of Madras High Court in March 2009, and at present he is performing the duties of the office of the Acting Chief Justice as Acting Chief Justice. Sir, we are honored to have you today with us, and I would request you to please share a few words with us.
Good morning to all of you. Honorable Justice Sri M.M. Sundaresh, Judge, Supreme Court of India. Honorable Chairperson of Telecom Disputes Settlement and Appellate Tribunal, Sri D.N. Patel, my beloved brother and sister judges who have come here to grace this occasion, Mr. Wilson, Honorable Member of Parliament, Mr. S. Sanganarayan, Additional Solicitor General of India South, Mr. A.R.L. Sundaresan, Additional Solicitor General, Vice Chairman of Bar Council of India, GP, members of the Appellate Tribunal, Mrs. M.M. Sundaresan, Mrs. Patel, and other dignitaries, members of the bar, ladies and gentlemen. Indeed, it is a great occasion. I am delighted to be part of this seminar on telecom, broadcasting, and cyber sections, disputes and resolutions organized by this telecom authority. In fact, today we are here to discuss about the unlimited benefits and unthinkable benefits which we are going to get from this appellate tribunal. We got independence on 15th August 1947, freedom from the foreign ruler. We got remedy from the foreign rule. But we didn't get till we got independence on 15th August 1947, social justice, economic justice, and political justice. Although we got the political justice, gradually we were getting, and still we are getting, the social justice. Almost we got economic justice. On the day we got independence, we all know that India was only an agricultural nation, depending only on agriculture produce. Famine used to come, drought used to come and put us in grave problem. Cyclone would come, there won't be anybody to extend any helping hand to us. Today, if there is any cyclone, drought, earthquake, causing unmeasurable problems to our neighbors, we always stand first. When tsunami came in 2004, December, you all know that. Many countries came forward running with all helping packages. Ships were coming from aircraft, food grains, other medical items were all pouring in. But India told them, we have everything in our hand. We don't want anything from anybody. Not to so that we were not willing to accept any helping hand, but we have stood as a self-reliant, and we have achieved almost in every front we have achieved our development. But the point is, we are here today to discuss about the constitution of the Telecom Disputes Settlement and Appellate Tribunal. There were many problems, many areas, many problematic regions where we were not able to get a remedy. I would say freedom from the media trial. Before mentioning that, I must also say that this Telecom Disputes Settlement Appellate Tribunal is having larger and better jurisdiction than the High Court. All of us are all legal minds. We are not layman. You take the case of a civil court. Suit is filed for getting a degree for declaration, a degree for title, degree for injunction. If there are disputes between two or more persons when they are coming to the court asking for appointment of an advocate commissioner to go and measure the disputed land, region. Generally the court will be appointing an advocate commissioner. If it is in a E-road, the PDJ is there, or a municip is there, or a sub-court is there. The sub-court or the district court or the district municip will be appointing an advocate commissioner. Please go to that taluk and measure the property with the assistance of a tahsildar and the surveyor. Come and submit a report. If it is a district court, the district court will be appointing in the appeal or even in the original jurisdiction. Go to any parts of the Coimbatore, or if it is in E-road, go to any parts of the E-road. But if it is High Court Madras, original jurisdiction is there. The High Court of Madras can appoint anybody as an advocate to go to any parts of the state. From Chennai, the people can go to Tuticorin, people can go to E-road, people can go to Perambalur, Tanjavur, even Pondicherry. If it is original jurisdiction of the Supreme Court, Kaveri Tribunal, for example, disputes between two states or more than two states, the Honorable Supreme Court can appoint any one of you as an advocate commissioner to go to any parts of the India within the territory. Look at the surprising, the jurisdiction of this Telecom Dispute Settlement and Appellate Tribunal. They are enjoying the over territorial jurisdiction, extra territorial jurisdiction. I will tell you one. I was sitting 3 years ago in 2019 and 20 in Madurai. Writ petitions were filed asking for injunction against a bank and also asking for damages. A businessman has deposited huge money. The first day, 10 lakhs was siphoned. The second day, another 10 lakhs was siphoned. A sum of rupees, another 10 lakhs was also siphoned. Third day. It goes on like this. Fourth day, fifth day. And then immediately was coming and then filing a petition asking for injunction. And injunction not to disperse any amount to anybody, including myself, because he says that my card, the credit card, has been forged. My money has been completely taken out. Injunct the bank, including against me, against my number, and also ask for damages 2 times more than that. Then notice was issued. The bank came and said, Lord, nobody is responsible. A person sitting in Nigeria has taken out the money. But how do we go to Nigeria? How do we catch hold of this, the great person, the person who has been doing this? Look at the brain. State police is unable to do. Central police is a big challenge. How are you going to encounter all these unforeseen, unthinkable problems? I mentioned to you just now that this Telecom Disputes Settlement and Appellate Tribunal is having larger jurisdiction than the High Court. And I must say, the presiding officers, chairman and every member of the tribunal can appoint an advocate commissioner to go even outside the country to Nigeria, which neither the High Court nor the Supreme Court has got the jurisdiction. Of course, in appellate jurisdiction, they have got the jurisdiction, the Supreme Court. And you are larger than the High Court. And you have the more power than the High Court. And you have the more challenges in the High Court. Therefore, you have the more responsibility and the more duty, more onerous duty to discharge. And we are all here to help. Now, coming back to the seminar on the telecom broadcasting cyber sectors. We got independence, but ultimately what happened to these areas? There were several areas where we were not even able to penetrate. Take the case of the people who are facing trial in both places. A very peculiar problems have come up. If somebody who is living in the higher pedestal in the society is facing some criminal case, media trial is always held. In view of the media trial, you see all the paper, all the broadcasting corporations, TV channel, radio, print media, everybody would be writing A, B, C, D, all these things, which you will not be able to find any substance over there. The result is, I would say, two important problems are all thrown into the court campuses. Lawyer will not be able to argue the case because the media trial is there. It has already completed the media trial, saying that if A has appeared for B, and as per his assessment, A's assessment, and as per his reading, as per his judgment on the evidences, if the advocate comes to the conclusion that no, my client is innocent, there is no evidence whatsoever, the prosecution will not be able to substantiate the case. But still, problem is the media trial has already given the judgment. If he is arguing the case before the court will be finding it very difficult to receive all the arguments. Even if it is a good, acceptable argument, the advocate will be facing problem. Courts will be facing problem. You know why? It is not being channelized. Nobody knows how to bell the cat. But thanks to this establishment of this telecom dispute settlement and appellate tribunal, after this tribunal, appellate tribunal has come into existence, people can easily go to this tribunal and you can stop it. And you can say that, let them produce the evidence. But when the competent criminal court or a civil court has seized the matter, what locus standi, what legitimacy these media, print media, or the broadcasting agency can condemn a person before being heard? In case if they exceed the limit, the remedy is always there. Twofold remedy. One, this appellate tribunal can stop it. The media trial is also brought under this jurisdiction. Thank God that today justice is being done to all the persons. These are the areas where we were not able to approach anybody. Today the remedy has come before your doorstep. After the establishment of this telecom dispute settlement and appellate tribunal, look at the very important and greatest the solution. Answer, you got it. If you are just going to the High Court against an order of suspension or against an order of termination, removal, you all people know as a lawyer, immediately the moment you are going to the court, you won't be able to get the remedy, stay of operation of the suspension order or a stay of operation of the removal, termination. Generally, if it is a suspension order, you will be able to get it at least after notice to the other side. But a removal order, termination order, or the dismissal order, you all know that the basic principle that generally is not stayed unless there is a very, very grave, error committed by the authority while passing the order of removal, dismissal, and termination. You will get the remedy only when the final hearing is over. You have to wait for how long? All depends upon the court. All depends upon the other side, how they are going to cooperate, how they are going to make your pleadings complete. For getting an order of suspension, if it is wrongly passed without jurisdiction, also you have to wait, and your litigant your client has to suffer a lot. How much humiliation a person, for example, an IAS officer, IPS officer, or some top-ranking officer working in either the public sector undertaking, central government, state government, or any establishment, if he is unnecessarily, without any jurisdiction, he is placed in a suspension, how much problem? If an officer, if a breadwinner of the family is sitting at home on the ground that he has been suspended, can you just imagine the humiliation? Can you just imagine the insult the family is going to face? Problem is this. Because of the overpopulation. Everywhere, every day, hundreds of matters, thousands of matters are all filed. Even though you have a good case, even though you have a meritorious case, even though the court is going to give you remedy, but because of the overpopulation, the explosions, you are not able to get it. Thank God that this Telecom Dispute Settlement Appellate Tribunal has completely taken away the burden of the High Court. Today, if this tribunal is really functioning independently, namely, no doubt about the independent functioning, but if it is functioning without any problem, infrastructural facilities like our Mr. Wilson mentioned, that they are also entitled to have a space. He mentioned to you that, also made a request to me. If the chairman is making a request, I will consider that. He should not say that I did not ask for that, only Wilson came and made only oral observation, but why the High Court is running fast to us now? If from competent quarters, if a genuine request is made, then definitely we will consider. And see, it is good because you will be coming, and then the brief lawyer will be going there, sitting over there and listening what is the nuances of these problems, telecast problem, and what are the problems the appellate tribunal has been addressing to the people. Today, this appellate tribunal is not dealing with what we call the problems emanating from the telecom communications, the telecom sectors. It is also invested with additional jurisdiction, the broadcasting problems, the problems emanating from the broadcasting areas. And also, it is also invested with the other problems which are all coming from airport. See, the tickets are all completely, see, if you are going to see your loved ones, one day before Deepavali, one day before the important functions, 5,000 would be your cost from Chennai to Madurai, and then 8,000 rupees would be there from Chennai to Delhi. But if you are going to from one city to another city, from Chennai to Trichy, this will be 18,000 rupees. Where are we going? You cannot come to the High Court. You cannot go to any other place. But today, this Telecom Disputes Settlement Appellate Tribunal has come to us to listen to our problem. 22,000 rupees, 30,000 rupees, 40,000 rupees from Chennai to Delhi, sometimes 60,000 rupees. Where are we to go? We can go and knock at the door of Telecom Dispute Settlement Appellate Tribunal, and I wish you should have a regular sitting in Chennai. If you have a regular sitting at Chennai, people from Chennai, people from the southern region will be able to come easily, effortlessly they will be able to come and get their remedy. In addition to these two things, namely the problems emanating from these telecom sectors, the problems emanating from the broadcasting sector, the problems emanating from the air traffic, air tariff, and the airport authorities, and also problems emanating from the other area. Everything can be adjudicated upon only before these people. The result is today, you need not unnecessarily go to the High Court. You need not unnecessarily go to the civil courts. Civil court doors are all completely closed. The High Court doors are all closed for the reason that you will get a speedy and a remarkable quick remedy from these people. These people, the remedy which you are going to get from the hands of this Telecom Dispute Settlement Appellate Tribunal will be a precise one, definite one, and authoritative one. For this reason, I would tell you. See, in the High Courts, every 3 months in some court, in some High Court, or in some High Courts every 6 months, or in some High Court every 1 year, the portfolio will be changed. In Madras High Court, we change every 3 months the portfolio. If I am today taking care of this second appeal, then after 3 months I will be taking care of the first appeal. And after some time I will be pushed to the service portfolio. After some time, general miscellaneous, tax side, custom side, it goes on like this, arbitration side. But this is the tribunal, this is a telecom disputes settlement appellate tribunal. From day one, all 365 days, they will be dealing with this problem. They will get expertise opinion and they will become expert, and nobody will be able to challenge their decision, their assessment. Therefore, the filing of appeal before the higher courts will be completely reduced. And therefore, I would say that this telecom dispute settlement appellate tribunal is a boon to people who are coming from all these 4 areas, namely the telecom sectors, broadcasting sectors, Aadhaar sector, airport region, airport sectors. So, pardon? Yes. So, this would have been set up very, very long time ago, after we got independence in 1947. So, this type of tribunal ought to have come and ought to have assisted us. Today, we are having it here today in Chennai. And I must also tell you that the problem emanating from the telecom sector is almost today has taken us to the place where we will be getting instantaneous remedy. But I must also remember one thing, that when telephone was invented in the year 1876 by Alexander Graham Bell, how it has changed, it has undergone the transformation. First time the landline telephone was invented. These telephones have undergone what you call the wireless, and then subsequently from cordless to wireless, and from wireless, what happened. Everywhere, every citizen, every officer is keeping minimum 2 cell phones. But sitting at home, you can just transfer your money in the bank. Whether you have a bank in your hometown or whether you have a bank in Delhi or Bombay, you need not go to that place. And if the more benefit you are going to get, the more problem also you are going to get. You will not be able to visit your bank to check up whether the check which you have deposited has been honored or it has been bounced. Look at the problem now. The moment any problem is arising in your account, in your bank, the bank manager will be able to communicate to you through your phone. But although you are getting the problem, but the remedy has become very big question now. Now the remedy is also available before this telecom disputes settlement appellate tribunal. Therefore, I would say that the telecom disputes settlement appellate tribunal who have come here to take care of the problems of the citizens, I hope will definitely go beyond the expectation, and I wish them all success to fulfill the expectations of the people. Thank you for the opportunity given to me.
Our honorable chief guest today requires little to no introduction. I am honored to invite Honorable Mr. Justice M.M. Sundaresh, Judge, Supreme Court of India, to share a few words with us today. Thank you, sir.
Thank you, Payal, for acceding to my request. She said I would like to give an introduction. I told her. the past good deeds of a judge should speak for itself. If he does a good job, he is answering his constitutional duty, nothing more. Honorable Justice D.N. Patel, Chairperson TD SAT, Chief Justice Acting, my good friend T. Raja, other dignitaries on the dais, my sister and brother judges, Justice Anita Sumant, Justice Abdul Quddus, Justice Saravanan, cumulatively constitute the future of this institution. Senior advocates, learned advocates from the bar here and Delhi, better halves, ladies and gentlemen, and finally, my dear students, a very good morning to all of you. I have a serious grievance against Mr. Prabhakaran. Being the leader of the bar, you should make sure that lawyers are here. What do we have, for what purpose do we have this function? This jurisdiction is one of the largest jurisdiction ever which you are going to witness in the years to come. Yes, the same goes to Amal Raj also. We have to grab the opportunity. Speakers have clearly indicated the contours of this disputes. Certain invention, yes, Justice Raja has put it. Do have the effect of steering the society. They completely change various segments of society, starting from an individual family to nations. He mentioned about telephone, electricity, printing press. Unimaginable changes have been brought forth. What would be the impact of the electricity? What would have been the impact at that point of time? It changes a night into morning. It changes the entire functioning of the society from a child, from a woman, from a man. And consequently, all the work attributed to them. It made them to move from one work to another work. It destroyed the boundaries, enhanced knowledge. When the society changes, when the knowledge increases, it creates more awareness. And therefore our role comes in. There are 5 important elements which are required for a nation. A robust health, good productivity, sufficient wealth, orderly society, and a strong army. Make no mistake, economy is a golden thread which connects all these factors. Today, telecommunication is playing a pivotal role in breaking the boundaries, completely overturning the social structure. We all do know about it. As students of law, we need to understand, appreciate, and adapt to the changing scenario. This is what I'm emphasizing upon. Law students are here. Please understand and appreciate the change. Change is permanent. Now, TDS Act, it has been introduced by way of an amendment which the chairperson has said in the year 2000. Now, if you see the 1997 Act, TRAI Act, which other is called, it is a regulatory body having adjudicatory powers. Learned Additional Solicitor General has flagged off an interesting issue on the question of arbitration. I would like to say something more on that for all of you to ponder over. TRAI is adjudicatory and also regulatory. Disputes can be multiple. It can be between a licensor and a licensee, between various service providers, between a service provider and consumers, broadly speaking. But if you see the provisions of the Act, an element of decision on rem would come in, which is again he was referring to. This appellate forum has to adjudicate an issue, a dispute, by treating it like a suit. But, as Mr. Wilson has said, powers are much wider, which again echoed by Justice Raja. Powers are much wider. This is not a normal tribunal which we have witnessed, where you will find restrictive powers are being exercised, being a creature of a statute. Procedure can be formulated by the TDS Act on its own. When TRAI has got adjudicatory power, that power can be questioned before the appellate authority. So it has got a different role to play. It is also not bound by the Code of Civil Procedure. It has got a power to condone, and interestingly, the power to execute its own decision by treating as a decree. Now look at the subjects, which again the chairperson has informed all of you. Multiple subjects, starting with dispute regarding telecommunication. The subject telecommunication is too wide. Broadcasting, cable systems, Aadhaar, and airport tariff, Now, these disputes would emanate from different circumstances. Please do not have the mindset that this is only meant for industries, businessmen, licensees. It is also meant for common men. We all use the cell phones, mobile phones. Dispute arising from those issues. Prepaid phones, reconnections, broadcasting issues with televisions, just as Raja again said. Dispute regarding Aadhaar. Now, what is going to happen? You will find a considerable fall in the conventional disputes, as even cyber issues are also being tagged into it now. TD's has not only got original jurisdiction but appellate jurisdiction as well. Unless we know the provisions, particularly the subjects involved, we will be losing it out. Troy Act, under the powers conferred, perhaps in section 35, resulted in numerous rules being framed. There are multiple rules for broadcasting, telecommunications, cable networking, and so on, also for other fields. There are many such regulations also. As a practitioner of law, one has to read these rules and regulations to understand where the right lies. Therefore, just kindly don't have the notion that it is a dispute between service providers. I have dealt with few of the cases in the Supreme Court. Cases pertaining to airport tariff. The appeal to the Supreme Court is just like a second appeal under section 100 of the Code of Civil Procedure Code. We do have our own difficulties in understanding the nuances there. It took considerable time because we never had the exposure in these fields. Now, as the appellate forum and original forum, though having a trapping of a civil suit, the TRI's actual jurisdiction power will have to be understood, particularly in the light of the appeal provided before the Supreme Court, which restricts the scope. Mr. Wilson was saying that it's a welcome change that a circuit bench has come to Chennai. I thank and congratulate the chairperson for taking efforts in this regard. The permanent benches here, regional benches, I would only imagine they are of a necessity, and therefore they are going to come one day. We are going to have explosion of disputes. So, my dear friends, be prepared. Access to justice is a constitutional right. A right which has been repeatedly emphasized by the Supreme Court. We are going to get it. Please get ourselves exposed and serve the litigants. Thank you very much for giving this opportunity.
Thank you very much, sir, for your kind words. Now I would request Shri Manjul Bajpai, President Telecom Lawyers Association, to please come and give a vote of thanks. To introduce a little bit, Mr. Shri Manjul Bajpai, the President Telecom Lawyers Association, has been practicing for over 3 decades and has been involved in almost all major issues and litigants. He's also mentored all of us lawyers who can stand here today, and possibly, sir, thank you for your guidance. Thank you.
Good morning, everyone. I'm honored and privileged for this opportunity to propose a vote of thanks on this August occasion. These seminars have now special significance because these are being held together with TDSAT benches sitting outside Delhi for the first time in 25 years, 20 plus. It was some time back, maybe last occasion, when Justice Patel had told me that the standard or status of a gathering is judged by the scholars gracing the occasion, and I have no words to judge the scholarly gathering here. Thank you for this learning having been given to us, Justice Patel. Sirs, I express my profound and most sincere gratitude to you all for honoring our invitation. We are greatly honored by your gracious presence and have immensely benefited by your inspiring addresses. I express our deep and heartfelt sense of gratitude to Mr. Justice M.M. Sundaresh, Judge, Supreme Court of India, for sparing his precious time and for his views expressed today, and particularly the need for the dispute resolution in changing times. He had referred to the wide powers of the TDSAT and that these powers need to be used for benefit of common man. Thank you very much, Justice Sundaresh. Thank you. I also express our sincere thanks to Honorable Mr. Justice T. Raja, Acting Chief Justice of Madras High Court, for gracing the occasion today. Justice Raja highlighted the importance of telecommunication during calamities particularly. He also referred to the wide jurisdiction of TDSAT. In fact, I am reminded that both Justice Sundaresh and Justice Raja's views are absolutely correct. In fact, in a 2003 judgment, Supreme Court has actually held that TDSAT has wider jurisdiction than Supreme Court, sir. Justice Raja also referred to the speedy justice and this system being a boon to the benefit of the sector. In fact, this 2000, before 2000 amendment, there was a 4-tier, sir, there was a 4-tier system. Now the appeal would first go to the High Court, then single judge, then division bench, and thereafter land in the Supreme Court. Now there is a provision for direct appeal to the Supreme Court from judgments of TDSAT. Mr. P. Wilson, Senior Advocate and Honorable Member of Parliament, Raj Sabha, very special thanks to you, sir, for gracing the occasion today. Sorry. Mr. Wilson referred to the economic growth, bringing need for commercial dispute settlement, and he has emphasized the need for regional benches, of course, and He's also referred to certain bill pending in the parliament. We all wish that this keeps happening so that we get more and more opportunities to visit all these places and meet all of you and also dispense justice to everyone in the country. And that has been, in fact, one of the objectives of this, holding these seminars to educate and inform everyone in the country. And starting from 2003, we have been holding these. Thank you very much, Mr. Wilson. In fact, I forgot, Mr. Wilson also stressed on the importance of infrastructure, which is very, very important. So no doubt about it. And we must do something about it, much more than what we have done. Thank you, Mr. Wilson. Mr. S. Shankar Narayanan, SG South, thank you very much for gracing the occasion, sir. Mr. Shankar Narayan had referred to the tribunalization, and it appears that originally Mr. Shankar Narayan was not in favor of tribunalization, but Justice Patel, I need your attention, sir, Justice Patel, that it appears that your words and your figures which you shared with us has changed the views of Mr. Shankar Narayanan, who was earlier against the tribunalization, is now in favor of the tribunalization because of the disposals which TDSAT has delivered, and particularly Justice Patel, 90% disposal, including mediation. Thank you very much, Mr. Shankar Narayanan. So, thank you. Coming back to TDSAT, Justice D.N. Patel gave us the figures which made Mr. Shankar Narayan change his views about the disposals, and he also educated us on the jurisdiction of TDSAT and issues which TDSAT deals with, and gave us figures of mediation. Thank you very much, Justice Patel. Thank you. I also express my deep regard and thanks to Mr. Justice R.K. Gautam, member TDSAT, and Mr. S.K. Gupta for their support and guidance in holding today's seminar. Thank you very much, sirs. I especially acknowledge the presence of Justice Anita Suman, Justice Abdul Qudus, and Justice Sarvanand. Thank you very much for gracing the occasion, my lords. Before parting, on behalf of the TDSAT and Telecom Lawyers Association, I take this opportunity to also thank each one of you for being with us today and participating in this seminar and making this a grand success. A very special thanks to all the lawyers and my learned friends who have come all the way from Delhi with their files in the boxes to ensure that the hearings here take place effectively, and the bench can deliver justice to all in all corners of the country. Very special thanks to the staff of TDSAT also for carrying all the files and books here. Thank you very much, all of you. Thank you.
Sir and ma'am, can I please trouble you for a photograph? If Good morning to the honours. Today it is indeed our fortune and honour to be in the august company of finest legal minds and lawyers to step into the field of litigation and guided them through their wisdom. Mr. Justice D.N. Patel for its innovative and path-breaking initiatives which is magnifying competition, explosive growth and rapid advancement of technology in the telecom sector. The telecom TDSAT has successfully dealt and resolved all kinds of disputes and has always inspired confidence among Honorable Mr. Justice D.N. Patel, who is not only credited for his innovative litigation. While I'm sure we can all go about our happy experiences, but it's time to... I would request my colleague Shri Sharat Sampath and listen to the words of wisdom today. And first I would like to introduce our very own Patel, Chairperson TDSAT, who needs little to no introduction. Every advocate who's present, Patel, has had their life affected in some way and has had the opportunity of gaining new knowledge. Revolutionize, I emphasize, the procedures of the tribunal, which not only...
Good morning, TDSAT. Mr. Manjul Bajpayee, President, Telecom Lawyers Association. Sri Sundaresan, ARL, Additional Solicitor General of India, Madras High Court. Sri S. Prabhakaran, Senior Advocate and Vice Chairman, Bar Council of India. Sri Kumara Gurubaran, Secretary IT and